Good evening, everybody, and welcome to our Wednesday night AJ Zoom. Tonight, we are very privileged to have all of you join us, those who are here live with us on the Zoom meeting, on our Facebook Live, and who are listening tomorrow on the replay on J-Air. Now, Israel is under attack internationally through organized lawfare. What is Israel's legal position, and what can it do to defend itself? This is our topic tonight, the international legal war against Israel, and we are incredibly privileged to have Natasha Hausdorff, one of the UK lawyers for Israel, join us tonight. Natasha has become one of Israel's leading defenders internationally. She is a barrister, director of UK Lawyers for Israel, and she previously clerked for the president of the Israeli Supreme Court. Now, before we kick off, I'd like to remind you, if you have any questions for Natasha, please write them in the chat or use the raise hand button, and we will get round to you in a Q&A after Natasha has done her presentation. Thank you for joining us, and please give a warm welcome to Natasha.
Well, thank you very much for that introduction. It's a real privilege to be invited to address you, I think especially in these times. And what I would propose to give a brief overview of before taking as many questions as possible is some of the recent developments in lawfare initiatives against the Jewish state, both at the International Court of Justice, which I'm sure our audience will have been following very closely, also at the International Criminal Court, and how those factor into other lawfare initiatives that we've seen both at international organizations like the United Nations and also in domestic contexts. But to perhaps put all of this into the appropriate context, even though many of our audience may have only recently come across both the nature and the impact of these sorts of lawfare initiatives, I think it's extremely important to bear in mind that they are unfortunately nothing new. I have been very privileged to serve as a volunteer at UK Lawyers for Israel for over a decade now. And although it's an organization that deals or that started off primarily dealing with the proper application of law to Israel, Israelis, to combating anti-Semitism in the United Kingdom, pretty quickly on, early on, we started to have to grapple with the application and misapplication of international law to Israel. And my public international law academic background was something that I called upon pretty early on in my experience with UK Lawyers for Israel, in starting to grapple with the trends that I was witnessing over a decade ago. There is a very important article, I think, that was in the New York Times in 2011. It was written by Mahmoud Abbas, who is still serving as the Palestinian Authority president. He is now in his 19th year of his 4-year term of office. But this article, which I think for a long time went unnoticed, called in 2011 for the internationalization of the conflict as a legal, not just a political matter. And this was Mahmoud Abbas's declaration of lawfare against the State of Israel. The practice of lawfare had been developed even before, but in this article, Abbas specifically called for cases to be brought against Israel at the ICC, the ICJ, and other international legal institutions, UN bodies, and human rights institutions. And when I say this was the declaration of lawfare by the Palestinian Authority against Israel, it came after many decades of the failed attempt to wipe Israel off the map militarily. Not just by the Palestinian Arabs, of course, but by Israel's neighboring states. And there was a marked shift away from attempted military conquest to an international campaign of delegitimization and the use and abuse of international law for the purposes of that campaign has been the work of several decades. We have seen the way that UN resolutions are passed accusing Israel of breaking international law. We have seen also resolutions brought in the UN Human Rights Council making all sorts of unfounded allegations against Israel, but invariably invoking legal concepts to do so. And most recently, we have seen renewed efforts against Israel at international legal institutions like the ICJ and the ICC. Now, the International Court of Justice sits in The Hague. It is the court that deals with disputes between states, and it also deals with applications for what are called advisory opinions, advice by the court to institutions like the General Assembly on issues of international law. Critically, those advisory opinions are not legally binding. And it's also important to note that they're not meant to deal with contentious issues or disputes between states. There is a separate mechanism for disputes between states to be litigated in front of the ICJ, and that requires both states to consent to that procedure. An advisory opinion is meant to deal with general aspects of international law that are of importance to clarify the law for states all around the world. And what we have seen most recently, and this was over the last week, the oral submissions ended on Monday this week, was a series of oral hearings vis-a-vis an application for an advisory opinion against the State of Israel. This was in fact brought by the General Assembly to the International Court of Justice in December 2022. So it has simply taken this long for the matter to come before the court for these oral hearings over the last week and a day. And it's important to recognise that throughout that process, there have been already substantial written memorials put before the court by many states. Over 50 states made submissions also orally to the court. About 10 of them had something relatively positive to say about Israel. And it's important to understand that the question that the court was asked by the General Assembly, which forms the basis of this request for an advisory opinion, is itself a very unusual one and a prime example of lawfare. It lists a whole host of allegations against Israel, accusing it of being an occupier, accusing it of violating the Palestinians' right to self-determination. And rather than asking the court to opine on the veracity or validity of any of those allegations, it asked the court to take that litany of allegations as a given and simply to advise the General Assembly on what the legal consequences ought to be of Israel being this beastly violator of international law. Now, I'm very happy to go into some of the legal arguments and the basis upon which certainly I would argue, and we have argued, UK Lawyers for Israel put in a submission to the International Court of Justice together with ELNET, an international organisation, that simply said that the court, amongst other things, wasn't in a position to in fact deliver the advisory opinion that was asked of it because it didn't have appropriate information before it. What has been provided to the court to support its decision-making process in respect to this opinion is thousands of pages, if not hundreds of thousands of pages, of false allegations against Israel and material that has been generated by NGOs and also by UN bodies making these false allegations against Israel, generating this sort of faux evidence that the court is being asked to take as a given for basing its legal opinion on. Now, there's a track record on this. The court gave an advisory opinion already in 2004 on the so-called wall, the wall opinion relating to Israel's security barrier that was erected in respect of the wave of suicide bombings that the Israeli civilian population was subjected to throughout the Intifada. And that security barrier, of course, as our audience may know, was in fact entirely successful in stopping that wave of suicide bombings. Nonetheless, when the court made its assessment of what it considered on the legality of that barrier, it did not at all consider the security rationale. and it's faced significant criticism, not least from the Israeli Supreme Court in Jerusalem in subsequent cases, because of the way that it approached that advisory opinion and the absolute absence of any reasoning, evidence, or rationale that explained the security need for Israel to build that barrier. Unfortunately, in the context of the advisory opinion that we see the court now being requested to give, the same is true. It does not have the proper material before it to make this assessment, and it is also being requested to upend entirely the internationally agreed process by which Israel and the Palestinians have been intended, certainly for the last 30 years since Oslo, to reach a final settlement through a bilateral negotiated set of negotiations. Often they're referred to as without preconditions. This has been endorsed certainly by UN resolutions, by the statements of many members of the United Nations. And here the court is being asked to throw all of that out of the window, to disincentivize the Palestinian leadership from coming to the negotiating table, and in fact to rule that Israel is in violation of international law, contrary to, I would say, what the law actually says, and certainly what the evidence would say if the court were to take that into consideration. So that's one aspect of the proceedings against Israel before the International Court of Justice. But of course, before last week, the word on everyone's lips, so far as the International Court of Justice was concerned, was South Africa's case against Israel. And this is an example of the other type of case that the International Court of Justice hears, namely a state-to-state case, a dispute between states. And the reason that South Africa was able to bring this case against Israel is because it used the hook of the Genocide Convention. That is a technical explanation for the allegation that South Africa brought. It is, I would suggest to you, utterly without merit. We can come on to certainly the absolutely morally repugnant suggestion that the real victim of genocide on the 7th of October, of acts of genocide perpetrated by Hamas, Palestinian Islamic Jihad, members of the PFLP, Fatah, all of those terrorists and some civilians that crossed the border and committed these unspeakable atrocities on the 7th of October, they were committed with the intention of attacking Jews as a group. There is genocidal intent, there are acts that qualify, and if anyone was in any doubt, the Hamas leadership have stated their intention of committing the 7th of October over and over again. And yet, South Africa saw fit to accuse the victims of genocide of perpetrating that very crime. That is not uncommon. We frequently, unfortunately, see Jews being accused of the very crimes that are perpetuated or perpetrated against them. But the technical reason that South Africa brought this allegation was, in fact, as I say, as a legal hook to bring this case against Israel, because Israel is a party to the Genocide Convention. And as part of that, it has accepted the court's jurisdiction over the Genocide Convention. So as a result, Israel has participated in these proceedings, the utter farce that we saw in terms of the application that South Africa brought against Israel, unlike the fact that it has refused to participate in the advisory opinion proceedings that I was just speaking about, because the use of an advisory opinion procedure in the context of the bilateral dispute, if you will, between Israel and the Palestinians is entirely inappropriate. And that, in fact, has been the content of many law-abiding states before the International Court of Justice, including the US and the UK, where I'm speaking to you from. In the context of South Africa's application, though, the case that was brought, and many of you may have seen the day of submissions that South Africa made vis-a-vis the provisional measures application. So this is why the case was heard so very quickly after South Africa's 84-page application accusing Israel of genocide. It applied for provisional measures. Chief amongst them was an order that Israel immediately cease its operation in the Gaza Strip. Now, South Africa wasn't successful in obtaining that. If you ask me, that would have been utterly contrary to international law. It would have been entirely contrary to Israel's inherent right of self-defense. That is not bestowed upon Israel by any international law. That is inherent. Every sovereign state has it. It is recognized by Article 51 of the UN Charter as being inherent. So it's perhaps not surprising that the court did not see fit to provide South Africa with the main thing that it was asking for. But South Africa has been immensely successful in the other aspect of, or the other motivation it had for bringing this application, and that is as part of its propaganda against Israel. Because Hamas have been celebrating both the hearing and the outcome at the International Court of Justice. And South Africa have claimed victory, and they now see fit to use the charge of genocide against Israel and to make that case internationally with impunity. What the court actually decided when it issued these provisional measures has also been the subject of gross misrepresentations. You, I'm sure, will have heard many people saying that Israel has been plausibly found guilty of genocide, or there is a plausible case that Israel has breached the Genocide Convention. That is not the case. What the court decided when it issued its provisional measures decision was that the case that South Africa brought under the Genocide Convention raised plausible rights under the Genocide Convention. Now, that is, I would suggest, a tautology. It is the lowest bar one could possibly imagine. But what the court ultimately determined was that the case that South Africa was bringing plausibly fell under the Genocide Convention. It did not consider breach of the convention. It did not consider intention, which is the crucial key element of the crime of genocide. It did not consider Israel's response. And that is pretty plain from the very short order that the court issued. Now, there's been lots of discussion by international lawyers about this decision. It has been praised as one which achieved essentially a broad number of the justices of the International Court signing on to it. There was the very brave and cogent dissenting opinion of the Ugandan judge Butinde, who has now very recently become the vice president of the court. But other than that, essentially, the other justices signed on at least to some of the provisional measures that the court ordered, if not all of them. And I think, very telling explanation that I've heard repeatedly that celebrated this order was that it was one that should be recognised as masterful because it enabled so many of the justices to sign on to it. Now, what that essentially is saying is that this document that essentially says nothing, that says that the case that South Africa has brought plausibly falls under the Genocide Convention, and that subsequently went on to order that Israel comply with its obligations under international law, which Israel has been clear it has always been complying with. This document that essentially says nothing new is one that enjoyed much support from the bench at the International Court of Justice. I mean, that is akin to passing a resolution at the United Nations. You pass a text that's toothless that everyone more or less can feel comfortable signing up to. And that is unfortunately what we saw in terms of what the court ordered. That certainly doesn't stop it being utterly misrepresented and presented as being something that far greater than the court has determined. There will be merits proceedings. There will be hearings probably over the next couple of years in which the court then considers the veracity of the case that South Africa has brought and the evidence that Israel has already in part presented against it, namely the measures that it takes to prevent civilian casualties and the significant and substantial humanitarian efforts in the Gaza Strip throughout this armed conflict, which are, of course, led by COGAT, the unit of the Israeli Defense Forces their only role is to look after the needs and the humanitarian provisions for the civilian population in times of armed conflict. So watch this space, but let's be, I would ask, extremely careful in terms of believing what is said, unfortunately, about rulings that come out of the International Court of Justice. I'll say a few words briefly about the International Criminal Court, because this is also sitting in The Hague, but very, very different in that the court has jurisdiction over the crimes of individuals, not states. And what I will say in respect of Israel is that it's important to understand that the court gets its jurisdiction from what is called the Rome Statute, which is the governing statute of the International Criminal Court. Neither the US nor Israel are signatories to this. That was as a result, as I see it, of certain indications through the drafting process of the Rome Statute that suggested that the court would be used for political purposes. As a result, neither Israel nor the US felt comfortable signing on to it, endorsing it, despite the fact that, in fact, they had both been pretty strong proponents for the creation of an international criminal court. Unfortunately, I think the fact that it has become so politicized and that it has such a woeful track record of seeking successfully prosecutions where they ought to be holding war criminals to account. Its sights have most recently been set on Israel. There was an investigation that was begun under the previous prosecutor, Fatou Bensouda. That has now continued under the current prosecutor, Karim Khan, and it has plainly been turbocharged after the 7th of October with a number of visits by Khan to the region and declarations that he will be pursuing investigations, he says, both against Israelis and against Hamas. That is extremely troubling in circumstances where, on a basic analysis of the court's jurisdiction, it has none, not in Israel over the crimes that Hamas committed on the 7th of October and subsequently, and indeed before, with the firing of rockets. Nor, of course, does it have jurisdiction over Israel. But quite apart from that issue and those challenges, the misrepresentation over the Israeli army's upholding of the laws of armed conflict, of international humanitarian law, are extremely troubling. And they serve as a cornerstone to what has been put forward already to the International Court of Justice seeking to target Israelis. And let's be clear, if that, as a result of that investigation, Karim Khan seeks to prosecute Israelis, there will be arrest warrants issued against individuals, which will make international travel certainly potentially extremely difficult. The basic position to set out vis-a-vis Israel's application of the laws of armed conflict are clear from Israel's track record through previous operations in the Gaza Strip. It goes over and above the requirements of international humanitarian law in terms of its targeting of Hamas and Palestinian Islamic Jihad terror infrastructure, in terms of the warnings and precautions it takes to prevent collateral damage and harm to civilians in extraordinary circumstances where Hamas's whole modus operandi is to use human shields and to seek to drive up the civilian death toll as much as possible to put international pressure on Israel. Hamas knows that it cannot win militarily now against Israel. Its only hope is to seek a pause or a ceasefire on the basis of international pressure that will enable it to survive. And that is something I would suggest law-abiding states, those that were in fact committed to Israel's war aims of eradicating Hamas immediately after the 7th of October, need to remain committed to and support Israel's efforts to follow that through and, of course, release the 134 hostages that Hamas continues to hold. Whether that is through a negotiated agreement, as we saw with respect to the first pause, or indeed as a result of rescuing those hostages, as we have seen now on a number of occasions. Israel remains committed, of course, to the release of hostages and to making sure that Hamas can never pose the threat, can never commit the sorts of atrocities that it did on the 7th of October ever again. So that is something I think critical to bear in mind with respect to the International Criminal Court, both the absence of jurisdiction and the fact that this investigation is now progressing on the basis of utterly false information, similarly, unfortunately, to that provided, put in front of the International Court of Justice. As a final word on this, I would say that it's important to recognise that these international legal institutions and the lawfare initiatives against Israel throughout those, and also at the UN, in the Human Rights Council and through UN special rapporteurs and their reports, these are all inextricably linked And it is a vicious cycle where one feeds into the other. And what we have seen in particular with respect to the International Court of Justice is that Israel's enemies are seeking a judicial stamp of approval on enormous amounts of UN reports that accuse Israel falsely of crimes against humanity, war crimes, breaches of international law. And if it succeeds in obtaining that judicial stamp of authority, that material will then also be deployed against Israel at other international legal institutions like the ICC, and also undoubtedly in domestic contexts, in proceedings around the world, potentially against individual Israelis. This is calculated, strategic, thought through, and as I indicated at the start of my remarks, it has been the work of decades. What is required is a forceful rebuttal, calling out the falsehoods, both in this material, but also in the application of international law as it is being advanced against Israel, and a very stern warning that the continued abuse of international legal institutions in this fashion spells extremely bad news, not just for Israel, but for all upholders of international law, all those law-abiding states, anyone who prizes the rule of law. Because what starts with Israel rarely ends with Israel, and what starts with the Jews in terms of terrorism, but also in terms of the abuse of international law, I would unfortunately prophesize, is unlikely to end with the Jews. And we are seeing a politicization of international legal institutions to promote these false allegations against Israel, which I think once that is firmly set in stone, will undoubtedly also be turned against other Western liberal democratic law-abiding states. And for that reason, we saw Germany very early on in the proceedings that South Africa brought against Israel, announcing that it would be making submissions on Israel's behalf. We saw the United States calling out the case that South Africa brought as meritless and wrong. And we saw the UK Prime Minister, Rishi Sunak, also saying that this case did not serve the purpose of the Court of Peace, and he was very worried about the potential, I would suggest, abuses of international law arising from it as well. We'll have to see what develops out of the hearings that have happened over the last week. But certainly there has been a shift in the dial. The speed and forcefulness of which these allegations are now being brought against Israel has been turbocharged after the horrific attacks of the 7th of October. And I would suggest, therefore, that the response to it needs to be all the more urgent and all the more robust. I'm very much looking forward to taking your questions.
Thank you for that outstanding explanation. I think it's all very clear now to everyone, so thank you so much. Before we go to some questions, we'll just get a very quick update from David. And I can see we've got a lot of questions, so reminder to everyone, put your hands up, and we may go to people who haven't asked questions before, so we may skip to some of those people. David.
Okay. Thank you very much. And as we do each week, at the end of the event, if you're not yet actively supporting AJA, please go to the website, make sure that you've subscribed to our emails, and consider making a donation, signing up. Make sure you follow our social media, Facebook, Twitter, Instagram, subscribe to the YouTube channel as well, to keep really on top of what's happening in the Jewish world in Australia and internationally. Now, next week we have another outstanding guest. We will be focusing on education. And as everyone knows, our education system has gone downhill on a range of benchmarks. We'll be looking at the declining standards, some of the radical gender theory that's in the education system, other activist undertakings, anti-Israel activism and anti-Semitism obviously will feature. And our guest will be the Shadow Minister for Education, Senator Sarah Henderson. I think you will be pleasantly surprised that we still have a few politicians of quality and Sarah Henderson is certainly one of them.
Okay, might start with a written question. In Australia, well, overseas, we saw the Biden administration put some sanctions against certain Jews in Judea Samaria. We've seen other governments follow. The AJA has a strong inkling that the Australian government may follow. So could you just make a comment on, whether this is unprecedented in the world or not, and what the legality of it is?
It's extremely troubling. And it is based not only on a misapplication of international law, but also on a bizarre focus and a misstatement of the factual situation. The UK, of course, has also followed suit, but this has very much been at the instigation of the United States. It's troubling in particular because of the context in it coming after the 7th of October. But the accusation that in fact that there is this sort of uncontrollable wave of settler violence is simply not borne out by the facts. The examples that the United States has seen fit to provide fail to address the context of many of these instances, in which, of course, there have been over 100. Well, forgive me, I'm now forgetting what time period that relates to, but the fact of the matter is that there are frequent terrorist attacks throughout the West Bank. Where there are elements of settler violence, this is taken very seriously by the Israeli government and the Israeli security forces in the West Bank, and there are legal repercussions and implications for that. So it is inexplicable and unfathomable, and I think attributable to a knee-jerk reaction, which one sees throughout, unfortunately, the international community, and this desire to sort of position oneself somehow in the middle with this both sides rhetoric. There is no comparison with what Hamas did on the 7th of October. There is no justification for terrorist attacks in the West Bank. There is certainly no justification for the conduct of a very small minority of sometimes referred to as hilltop youth that seek to stake outposts and may also involve themselves in elements of violence. But that is certainly not the norm. It is certainly not reflective of the population of Jews that lives in Judea and Samaria, and it is certainly not something that is ignored by government and by authorities there. So the justification for it is inexplicable, and in that respect, in terms of the legal underpinnings of it, of course, it is predicated on this notion that the presence of Jews in Judea and Samaria or the West Bank is in some way illegitimate, and that is without basis in international law. A lot of this stems from the allegation that Israel is an occupation. Now, quite apart from the fact that, in Gaza, the Palestinians have had self-governance since 2005, and in the West Bank, well, in fact, even before that, as a result of Oslo, but in the West Bank, certainly in areas A and B, the Palestinians enjoy an autonomy. So the realities of control are often misstated, but in a legal sense, the term occupation is utterly inappropriate. In a legal sense, the status of the territory, when we go back to essentially the Declaration of Independence, the founding of the State of Israel in 1948, to understand what the status of the territory is, there is a general rule of international law, a default rule which is universally applied, that tells us what the borders of states are at the Declaration of Independence. And in Israel's case, it states that Israel would have inherited the pre-existing administrative lines of the British Mandate in 1948 when Ben-Gurion declared independence. There is no basis that I have encountered for the disapplication of this general default rule in the absence of there being any agreement to the contrary. And in the case where Israel was the only state to emerge in 1948 from what remained of the British Mandate after the severance of Transjordan, which later became the Hashemite Kingdom of Jordan. The application of that general rule of international law is, as I say, universal. It was recognized by the International Court of Justice in 1986 as a customary rule of international law. And the court described its emergence in the 19th century in South America, its application in Asia and in Africa, its application at the dissolution of the former communist federations, Yugoslavia, Czechoslovakia, its application to states emerging from mandates. In all of these cases, uti possidetis juris has stated what the borders of those emerging states are. And it's critical, I appreciate this is an involved and detailed answer to the question, but it's just critical to understand how badly misrepresented international law has been here with this political term occupation masquerading as legal analysis. Because we have seen a parallel example where the exact opposite and the proper application of international law is in fact upheld in respect of Ukraine. The reason that Crimea is considered to be part of Ukraine's sovereign territory is because of uti possidetis juris, because of the administrative lines that applied when Ukraine obtained independence. Now, everyone appears to agree that Russia has occupied Crimea from Ukraine in the same way I would suggest that Jordan occupied the West Bank and East Jerusalem from Israel in the War of Independence, 1948 and 1949. But when Israel recovered that territory from Jordan in 1967, it has suddenly somehow been classed as an occupier. One cannot occupy what was originally one's own sovereign territory. Let's consider that parallel example. If Ukraine recovered Crimea in this current war that Russia has waged against it, would anyone accuse Ukraine of occupying Crimea? Of course not. And yet we see that false application of international law, these false allegations against Israel have provided the basis not just for the order that the US put out several weeks ago now, but also more recently for this supposed change in policy on Friday of last week that sought to reverse Secretary of State Pompeo's reversal of what was previously in place, the Hansel Memorandum, the analysis of the legality of settlements in international law. And we've had this recent political statement from the Biden administration that declared that settlements were illegal, that they were contrary to international law. Now, the prior statement of the legality of settlements, in fact, came from President Reagan, who considered them to be legal. But, a declaration of policy in one way or the other doesn't change the realities, doesn't change the application of international law. What it does in both of these respects, both the declaration and the sanctions, very, very troublingly seem to suggest that Jews cannot live in certain areas simply because they are Jews, and that any future peaceful agreement must in some way be predicated on removing Jews, on creating a Judenrein situation, which is, of course, what happened when Jordan ethnically cleansed the land that it occupied between 1949 and 1967. So there were deep, deep problems and concerns, I think. Who knows if those will persist after the next election in the United States. But if other states are indeed following suit, then all the more important that we robustly challenge the false basis upon which these new activities are predicated on.
100%, yeah. And if they do come in Australia, obviously AJ will challenge it. And if anyone wants a more sort of in-depth look, David recently interviewed Mark Zell, a US lawyer who's actually suing the Biden administration on this issue. So it's on our YouTube channel. It was an outstanding explanation. Yeah. All right, we're going to go to questions now. Everyone, one question per person, no statements, short questions. Okay, Terry, you're first.
Hi, thanks for your talk. It's comforting to know that there are some lawyers that are actually on our side. What you've described is a very robust, over time, defense of Israel, but it's always the case that whatever Israel is accused of by its enemies are doing to Israel. Is there any possibility that this could be turned around and used against certainly the Palestinian Authority, Hamas, take them to court?
So the real difficulty, I think, just to understand, how international law operates, there are two issues here. Firstly, it's primarily state to state. So states are the legal personalities in international law. And the other second issue is that it works really against law-abiding states. Rogue states ultimately end up doing more or less what they want, because the enforcement mechanisms in international law are few and far between. One has to have essentially a political consensus to support sanctions, or the isolation of South Africa, for instance, was a prime example, and it's no coincidence that it is as a result of the success of that policy against apartheid that Israel has been accused of apartheid, and the similar processes are being sought to be deployed against Israel in terms of sanctions and isolation. That is at the core of the boycott, divestment, and sanctions movement. So bearing in mind those two problems, holding those entities or indeed states that seek to attack Israel to account is extremely problematic. There has been a recent complaint by the families of hostages and victims, I know, to the prosecutor of the International Criminal Court in The Hague, to Karim Khan. And I can completely understand the motivation behind the application or the complaint that was made. The real danger of it is that it is encouraging the court to double down on its investigation where it lacks jurisdiction to pursue it, because it does not have jurisdiction vis-a-vis Israel, and that it is going to provide the cover or the political quid pro quo for Prosecutor Khan to justify arrest warrants against Israelis in the future. If he says, well, look, I'm also issuing arrest warrants against Hamas. Practically speaking, I will be astonished if any Hamas terrorist or Palestinian Islamic Jihad terrorist or any terrorist that is accused of crimes against Jewish people finds themselves in The Hague, prosecuted. But what is the danger is that that will be used as a justification for targeting Israelis. So in terms of the terrorist entities themselves, very difficult, of course, to hold them to account. The best that Israel can do is seek to defeat them militarily. And after the war, there will be, I'm sure, continued discussions about the best way of prosecuting those in Israeli courts, perhaps in special tribunals in Israel, for the crimes that they committed on the 7th of October, for the acts of genocide and the crimes against humanity. And international law has seen, previous ad hoc or special tribunals set up. Of course, Nuremberg is an especially famous one to deal with similar situations. But the real cause of all of this, of course, is Iran, the foremost state sponsor of terrorism in the region. And there are international legal responsibilities binding on all member states of the United Nations, importantly under UN Security Council Resolution 1373. Oh, good Lord. 1373. It's late where you are, but it's early where we are. So that was a resolution passed immediately after September 11th, and it requires all member states not to fund or otherwise support terrorist organizations. It is an important resolution because it's made under Chapter 7 of the UN Charter, and it is only Chapter 7 resolutions of the United Nations Security Council, which are extremely rare, that are binding legally. Every other resolution made by the General Assembly or those made under Chapter 6 of the UN Security Council are in fact political rather than legal resolutions. But this is legally binding. And absolutely, all member states of the United Nations have a responsibility to counter terrorism as a result of that. And we are seeing them fail consistently in their obligations. There's another key, actually, legal obligation that Egypt holds that nobody is talking about, and that is to facilitate the safe passage of refugees from Gaza into the Sinai. Egypt is a signatory since 1980. It's acceded to the treaty in 1980 of the African Union Convention on Refugees, which has a much broader definition of refugee than that in the International Refugee Convention, includes those fleeing civil disorder. And Egypt is under an obligation to use its best endeavours to facilitate the safe passage of those refugees. Now, when we consider the international community's outcry over the humanitarian situation, it is utterly inexplicable that there wouldn't be pressure on Egypt to comply with the obligations that it signed itself up to in 1980 to facilitate the passage of civilians through Rafah, where they can be properly provided for, the other side of the border, provided with humanitarian assistance, which is then not diverted to Hamas, as it is consistently being diverted in the Gaza Strip. And again, we're not seeing any international clamour. So there are certain legal obligations on states that can be being made more of. But actually finding a mechanism to enforce, I mean, that takes us, unfortunately, to the limits of international law and the important role that politics has to play in this. When we look at the role that Iran is undoubtedly playing in terms of its support for Hamas, for Hezbollah, and it's important to recognise the much hotter situation over the last couple of days on Israel's northern border. And of course, its support of the Houthis and their breaches of international law. I mean, Iran is getting away with an awful lot. And the continued efforts, it seems, of the current US administration to placate and appease the foremost state sponsor of terror in the world and such a destabilizing factor in the region is extremely concerning. And it really relies upon law-abiding states like the US, like Australia, like the UK, to step up and require the enforcement of these legal obligations. But it ultimately has to come from state level to be effective, I think.
Okay. Ron, would you like to unmute and ask your question? Can't hear you. I think you're...
Ron, there's something wrong with your microphone. Let's move to someone else.
Dr. Goldbaum, would you like to ask your question?
Yes, thanks. Thanks for your illuminating talk, Natasha. But my question is a little bit left field for you, and it concerns the role of Jewish women. And the question for you is, do you think that more Jewish women should play a greater and active role in combating Jew hatred? And if so, how should they do it?
Well, I think especially over the last few months, what I've seen is Jewish women being absolutely fantastic, and especially raising the issue of sexual violence at bodies around the world, at the United Nations, and calling to account all of those that, championed the Me Too movement. Me Too, unless you're a Jew, is a powerful accusation, which I think has started to really gain currency and call out the hypocrisy that we have seen both from international institutions and governments on this issue. But absolutely, the more the merrier. I think in Judaism, women have always played a very strong and powerful role, and all the way from Zelophehad's daughters and seeking justice and promoting feminist ideals even in the biblical era. So I think we've already seen that. I know that there are many international organizations that are fighting this fight. Shurat Adin, the Lawfare Project, the International Legal Forum, in fact all set up by women, and more power to them.
Amazing. Yeah, we've definitely seen a lot of amazing women, especially in recent times. And we've got a Hugh Kitson. Hugh's got a special connection with Natasha, so would you like to unmute?
Well, first of all, Natasha, I'd like to thank you for your participation in Whose Land, because you have greatly enriched the project, in my view. But I've got a slightly curly question, which is perhaps hypothetical, at least I hope it's hypothetical. Supposing the opinion that the International Court of Justice is now considering does its worst and seeks to expel basically all Jews from Judea, Samaria, and Jerusalem, and then assuming that Biden is still in office, which we hope he won't be, it then goes to the UN Security Council for a Chapter 7 resolution, which gets passed. What would happen then?
Well, of course, it would require, you know, a legally binding resolution for it to have any actual legal weight. The advisory opinion of the court doesn't. Although I would certainly acknowledge that so far as the previous court's opinion in 2004 is concerned, that has been seen as very authoritative. I think in the event that an opinion of the manner you describe is issued by the court, it's incumbent upon everyone who cares about international law to call it out in the same way as the 2004 Wall opinion was deficient, to call out the failures to actually make a determination on the basis of appropriate information and apply the law properly. But I think I would be very surprised if the follow-on, even in the context of this administration, if the follow-on scenario that you described materialized, because undoubtedly the Biden administration is treading a very difficult political line. And it's plain that, you know, both of its eyes are very sternly trained upon the polling data in advance of the election in the United States, and that has characterized, I think, some of the utterly schizophrenic statements that we've had coming out of the United States vis-a-vis the Israel's operation in Gaza. I think the scenario you describe in terms of a Chapter 7 resolution would be extraordinary. In those circumstances, I would hope that there might be other law-abiding permanent members of the Security Council that would see fit to veto it, because ultimately it is a saying that the West Bank needs to be ethnically cleansed of Jews, and that is plainly illegitimate, both morally, legally, politically.
Okay, Anna Berger, would you like to ask your question?
No, you haven't unmuted yet, Anna.
Is that better?
Yes.
Okay. Well, two issues, Natasha. Thank you for your wonderful presentation. But there are two things. First of all, this propaganda against Israel, defaming Israel as an apartheid state, as an illegitimate colonizer, etc., has been going on for a very long time. And at no point has there been any real serious counter-argument from Israel or any of the lawyers speaking for Israel. They have simply been led to, you know, on the assumption that everybody will think it's stupid, I suppose, but it isn't. It's been very damaging. It's been long-term dangerous. And the other issue I have is that nobody talks about the religious aspect, that Muhammad had enjoined his followers to kill the Jews and kill the perfidious Christians and all other infidels who do not follow him. Now, that was in the 7th century. And to allow those descendants of pigs and apes, the Jews, to live in what they call Palestinian land is anathema to most Muslims, but it's never stated.
Yep, so that's certainly an issue we've seen.
Well, so far as the legal case is concerned, I think I've been dealing with this for over 20 years. I've certainly been dealing with the legal arguments for over 10. And I know that there are a network of very committed lawyers and legal academics who are absolutely advancing the real analysis and important aspects of this that need to be put out there. There's a big fight to be able to gain currency, unfortunately, in the academy. And we know the position in universities that was being addressed earlier and will continue to be discussed in your next session. And then, unfortunately, in the legal academy in particular, there has been a vicious approach to silencing anyone who is telling it like it is vis-a-vis Israel and international law. But I agree that those arguments need to be advanced more forcefully, and the state of Israel is stuck with diplomatic considerations and balancing, you know, policy interests and maintaining the Abraham Accords, which are, of course, amazing that they have been able to maintain those positive relationships with the Accords countries, even after the 7th of October and everything we have seen throughout the region. So there are complicating factors, I think, so far as Israel making its own case is concerned. But as you say, with respect to the religious aspects, I see actually a bit of a sea change here in the last few days in the United Kingdom in light of the threats and intimidation associated with Islamist extremism towards the police, towards the parliament, which descended into chaos last week. And there have been a number of very impressive and robust op-eds this morning in particular, calling out that threat and that intimidation, and calling on the government to deal more robustly with it. So there is, the issues that you raised are certainly now being discussed in a way that I haven't seen quite in that fashion before.
I should say we've got a lot of good lawyers doing work here. Quite a few are in this Zoom with us, and some in the Lawyers for Israel group. We know they were doxxed because of standing up for Israel. So we do have a lot doing some good things. Ron, is your sound working? Are you with us? Can't hear you, so we might see what we can do. Maybe Dina, we'll go to you and see if we can work out what's going on.
Thank you. There are indications that Iran actually bribed South Africa to bring that case against Israel to the ICJ because it costs a lot of money and South Africa was broke. If that could be shown to be true, would that have any impact on this case?
It's a very good question. I've also seen those reports, and an awful lot of them relate to the ANC's election campaign. And I think that is being very hotly debated and contested within South Africa itself, especially by the Jewish communal organizations. I think that the court is probably going to take the arguments that are presented to it at face value. I don't see that there's any precedent for it investigating, the motivations, which is perhaps unfortunate. But the International Court of Justice judges will, I'm sure, be reading reports. They may very well have their own conclusions. Many of them, unfortunately, may agree with South Africa despite the motivation and despite its support of a terrorist organization. It's important to remember that the International Court of Justice, made up as it is by representatives or justices from states all around the world, not all of them have a strong rule of law tradition. Not all of them have the independence, perhaps, of their governments that we would hope that the justices of the International Court of Justice have. And so politics is undoubtedly going to play a significant role in the UN's court.
Okay, might have time for just one more question. So apologies to everyone with their hands up. We might go. Ron sent through his written question. He says, in the last few weeks, the US, UK, and other Western countries have said they would recognize the state of Palestine. How can they technically do that by bypassing the Montevideo Conference principles of statehood?
So the Montevideo Convention criteria, absolutely right, help determine the factors that are required for statehood, but recognition of statehood is in fact a somewhat separate matter. The so-called state of Palestine has, of course, already been recognized by tens of other states, those hostile to Israel. It's possible, of course, there's nothing stopping the United States or the United Kingdom, for that matter, from following through on their threats, but it would be oh so dangerous and so damaging, I would suggest, to any possible peaceful resolution of this conflict, and utterly tone deaf to the events of the last 4 months. It would be seen as a reward for the 7th of October, and ultimately it hamstrings any possible future negotiations. It completely upends, in the same way that I was describing vis-a-vis the International Court of Justice Advisory Opinion, it upends the framework that has been endorsed by the international community for negotiated solution. But also, critically, it is utterly unable to grapple with what the 7th of October should have shown the international community, which is the purpose of establishing a Palestinian state. And the so-called moderates in the Palestinian Authority have also been clear that it is intended as a platform for the further genocidal war against the Jewish state. The fact that these comments, even if they are meant for a political purpose or point scoring, the fact that these comments are being issued and uttered by key international players is so irresponsible And it is a plain refusal to acknowledge the responsibility that the international community has for what occurred on the 7th of October, with the constant pressure upon Israel to make security concessions, and the utterly misguided approach that it has taken. It is very interesting to note that one sees a different approach, I think, from the key players in the region, who understand the realities far better than the Western liberal democracies appear to, and who have probably therefore a very key and central role to play after Hamas is defeated, the Abraham Accords countries in particular, in taking this forward in a manageable fashion where Israel's security interests are protected.
Natasha, thank you very, very much for your educational and insightful words this evening. It's been a very engaging Zoom meeting, and I really do say sorry to the people we did not get around to. I know there are a million more questions that we would love your expertise on, but unfortunately we don't have time. To all our viewers, thank you very much for tuning in. We encourage you to share this with all your friends. The recording will be available on our YouTube channel and on our Facebook page. So please share this around, share the link, and make sure everybody has the opportunity to see this and to listen to some of Natasha's answers to the questions that were asked this evening. We hope that you'll join us next week at 8 p.m. with Senator Sarah Henderson, and we wish everybody a good night. Thank you. Thank you very much, Natasha. Good evening.
Thank you.